doctors. I'm Dr. Chris Rapoff of QME Continuing Education. Welcome to this week's Case Law Update. In today's Case Law Update, we're going to take a look at a coming and going rule and how this rule applies to a worker if they're injured or even worse, killed in a collision while on their way to work. Does this fall under our understanding of AOE COE, that is, arising out of and in the course of our employment? The late applicant's attorney thinks so, but was he correct? Well, let's take a look. Before we get started, let's, for some context, take a look at the labor code that we're all very familiar with. Labor Code Section 3600. Here we have a liability for a worker's compensation accrues for an injury that arises out of and in the course of employment, and that's Labor Code Section 3600, Section A. Now, according to the Smith versus the Appeals Board in 1968 ruling, they stated that under a well-established going and coming rule, an employee does not pursue the course of his employment when he is on his way to or from work. So they indicate that the injuries that are sustained while an employee is coming and going to and from the place of employment do not normally arise out of and in the course of an employment, because the employee, here's the kicker, is neither providing a benefit to the employer nor under the control of the employer during that commute. They indicate that this does apply to a local commute en route to a fixed place of business at fixed normal hours. Before we get started, this is the Isabel Ackerland versus the County of Riverside. And what we're looking at is a recommendation of the judge on a petition for reconsideration in the case. In this case, the finding and order was dated in November of 2021. And the applicant's attorney alleges that by the award, the workers' compensation judge acted without or in excess of their powers, and that evidence provided and presented does not justify the findings of fact, and the findings of fact don't support the order, the decision, or the award. Now, at the trial, the applicant's attorney contended that Ms. Ackerland was actually a decedent in this case and was required to use her personal vehicle for work in order to perform her duties as a behavioral health specialist, or BHS. The defendant contended that coming and going rule was applicable in this case. As a general rule, injuries sustained during the course of an employee's commute to and from work are not compensable, as I already mentioned. Now, some facts of the case. Ms. Ackerland was employed on this date of May 20th of 2019 as a behavioral specialist by the County of Riverside Department of Mental Health. And they claim that she's died rising out of and in the course of her employment. Now, on May 20th of 2019, Ms. Ackerland was involved in a fatal automobile accident. Here we have two vehicles that were involved in a head-on collision, and it was determined that the other driver crossed the double parallel lines and traveled the wrong way in the eastbound lane. The vehicle collided with Ms. Ackerland's vehicle, and she was killed in this accident. At the trial in July of 2022, they had a testimony by Ms. Jill Forbes, and she was Ms. Ackerland's supervisor on the date of her injury, or actually of her death, on May 20th of 2019. Now, Ms. Ackerland, as I had mentioned, was employed as a behavioral health specialist, and the supervisor testified that they are working at the direction of a psychiatrist or therapist. In addition, a behavioral health specialist develops relationships with clients. They work at the clinic. They also could meet with clients depending upon appointments. And sometimes they had appointments at the houses, their homes themselves, hospitals, or other clinics. Also, a behavioral health specialist could work in the field, but it wasn't required. And they also can go to and come from appointments with clients in the field. These job duties included assisting clients by talking to them, escorting clients to appointments also. And the staff member would take a county car to pick up the client to take them to the appointments. It was preferred, as she indicated, that staff members use a county vehicle to transport the clients. However, if a county vehicle was not readily available, they were able to use county fleet vehicles. Now, in this case, there was no evidence that Ms. Ackerland used her personal vehicles to transport patients in the past because the county vehicles were readily available. Her supervisor did testify that the use of a private vehicle was discouraged, however, it was permitted. Workers were not permitted or prohibited from using their own vehicles, period. Now, on the date of Ms. Ackerland's passing, she had not come to work and was not marked out on the board in the office. So Ms. Ackerland was not signed out for the morning of 5/20/2019, the day of her death as well. Some additional facts that they state that as a condition of employment as a behavioral health specialist, a California's driver's license and a minimum insurance coverage would be required. Now, this requirement became the basis for Ms. Ackerland's attorney's filing for the reconsideration. More on this later. But in the petition for reconsideration, it was alleged that Ms. Ackerland was required to work in the field and used their private vehicles to transport patients. They state, though, this is not an accurate statement of the testimony at trial. So the applicant attorney now, Ms. Ackerland's attorney, starts discussing the accident log. And there's an accident log that actually shows that employees were involved in motor vehicle accidents in their private vehicles. So there is some documentation here. They indicated that it's approximately 2% of the entries. So Ms. Ackerland's attorney was contending that the employees may use their own private vehicles while performing the job duties. However, the accident logs showed that the vast majority of the county workers used county-provided vehicles, and a very small percentage used their own vehicles while at work. So the use of private vehicles was the exception to the common practice of using a county vehicle, not the rule. Let's take a look at these issues at hand. So, as a general rule, the employees injured on an ordinary commute to a fixed place of employment at a fixed time are considered outside the course of employment. Now, injuries that are suffered on such a commute are not compensable unless they fit within one of the many exceptions resulting from the case law. This brings us to the coming and going rule. So this rule, the coming and going rule, vehicle use exception, states that in general, an employee is not acting within the scope of employment while traveling to and from the workplace. And if an employer requires an employee to drive to and from the workplace so that the vehicle is available for the employer's business, then the drive to and from work is within the scope of employment. The employer's requirement may be either express or implied. Now, also, the drive to and from work may be within the scope of employment if the use of the employee's vehicle provides some direct or incidental direct benefit to the employer. There may be a benefit to the employer if, one, the employee has agreed to make the vehicle available as an accommodation to the employer, and two, the employer has reasonably come to rely on the vehicle's use and expects the employee to make it readily available. The employee's agreement may be either express or implied as well. Ms. Ackerland's attorney contended that the decedent, Ms. Ackerland, was using her personal vehicle for the benefit of the employer because she was required at the time of her employment to maintain a valid California driver's license and for her to have a minimum car insurance policy on her vehicle. So they felt that that was enough indication that she was using that for a company purpose. And now they discuss quite a few cases regarding the coming and going rule that would be advantageous if you have the time to look at those cases yourself. So the appeals board weighs in and stated that in this case in particular, Ms. Ackerland was not required to use her vehicle to visit the clients. County vehicles were readily available for use. And based on her supervisor's testimony, there was no shortage of county vehicles to contend with. Also, that they indicated there was no evidence that she was required to furnish her own transportation. There was no evidence that she had taken homework to be done the evening prior, and there was no evidence that she was on a special errand for the employer as well. So in the present case, on the morning of May 20th, 2019, Ms. Ackerland was traveling from her home to start her workday at the county clinic. She was traveling in her own vehicle. Additionally, there was no evidence that she was going somewhere else or traveling to see a client. There was additionally no evidence that she was scheduled to use her vehicle at work that day at all. There also, finally, is no evidence that she was scheduled to leave the office that day to visit clients or to participate in training outside of the office. The appeals board continues to point out that Ms. Ackerland's attorney was attempting to expand the exception to the coming and going rule, and the argument saying that there was a requirement to maintain a California driver's license and a minimum car insurance policy is the same as requiring an employee to bring his or her personal vehicle to work. They concluded, the appeals board, that Ms. Ackerland's attorney was actually stretching the exception to the coming and going rule and denied the applicant's attorney's petition for reconsideration. In conclusion of this case, we actually are dealing with a very unfortunate situation where a worker lost their life, and the deceased attorney is trying to expand the interpretation of the coming and going rule as it applies to workers' compensation in the state of California. However, the appeals board disagreed with the attorney's take on the rule. As you can see, we're dealing again with an AOE-COE determination. Well, once again, doctors, I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I do look forward to talking with you soon and sharing some other interesting cases again in the near future. Thank you.